Uh, Great. I
Oh,
got it. Thank you. All right. Why don't we get started? Could everyone please mute yourself? Thank you so much. All right. So welcome everyone to today's webinar session. My name is Eugene Kwok. I'm co-hosting this event with Helen Marsh. And before we get started, I would like to introduce myself and tell you a little bit about the background of this webinar. Um, I'm a landowner in Orange County, and I'm really passionate about sustainable land management, environmental stewardship, but really most importantly, I'm really passionate about land access and housing for young and beginning farmers. My wife and I own a property which provides 30-year free land lease and an on-site affordable housing for beginning farmer family. And we now have multiple farming operation on our property, which we're really grateful for. I began this journey about 9 years ago, and it's been a really rewarding journey, and I've really experienced firsthand the challenges and rewards of the agricultural industry. But I realized that a shared passion can provide a sense of belonging and really empower each other, which is why I'm really especially grateful to afford this opportunity to host this webinar with Alain today. Um, this webinar stems from the network of Hudson Valley landowners who participated in American Farmland Trust and Glenwood's workshop back in 2022. Um, and it was really the core group of the cohort who continue to meet independently from that workshop. So August last year, Helen kindly hosted an in-person event on regenerative grazing, which inspired us to expand these conversations. And also in August last year, we held our very first webinar to cover a broad overview of landowners' resources. And throughout this journey, I've noticed that many farmers and landowner agreements are handshake based, and it really relied on just trust. So hopefully today's session, as it's titled, um, is really going to be providing an essential first step towards creating an equitable and just agreements between farmers and landowners. And today we're really honored to have two legal experts from Pace University, Professor Jonathan Brown and Jack Hornickel, who will share their insights on the legal process. They've been really instrumental in providing legal guidance to farmers and landowners in our region. And thank you both for taking the time to join us. I really do appreciate, just personally, I've benefited so much from your guidance and for your in-kind donation. Thank you so much. Before we make the presentation, I just want to go over some housekeeping rules here. First of all, please mute yourself. We're going to spend about 20 to 30 minutes on the presentation. Jack will lead the presentation, and during that time, please introduce yourself in the chat. Please share your name, a little bit about yourself, and your email address so that I can follow up with the material and also the recording of this session. Also, if you have any questions, you can please use the chat. I'll be closely monitoring those. And then after Jack finishes his presentation, I will go over those questions and deliver that to Jack for his response. The second half of this webinar, we're going to be allocating just a Q&A session so that you can raise your hand. I'll be calling your name and you can be much more engaged. It's going to be a very flexible Q&A session. So that's how we're structuring this webinar. And once again, thank you so much for all the landowners, farmers, service providers in the Hudson Valley. And Jack. Thank you.
Sure. Thanks, Eugene. Let me start with just a brief introduction, and I'll allow the same to Professor Brown. My name is Jack Hornickel. I'm a staff attorney at Pace Law School's Food and Farm Business Law Clinic. I've worked there for 4 years now. And prior to that, I worked for the Grow NYC Farmer Assistance Program in a similar capacity. And so my relationship to agriculture and to farm services really at the small, diversified, direct marketing scale. And I think I'll let Professor Brown introduce himself, and maybe if he could talk about the clinic more broadly while I get my screen share set up.
Sure, thanks. Well, first of all, thanks so much, Eugene. And it's great to see everyone here and a lot of new faces and some familiar faces. Like Jack said, I'm the director of the Food and Farm Business Law Clinic here at Pace. We're based in White Plains. And just very briefly, it's a law school program where law students have the opportunity to take a course for credit where they actually get to do real legal work on behalf of clients under the supervision of Jack and myself. And all of our clients in the clinic are small farms in New York State, or small food businesses, which are generally farm adjacent businesses, or nonprofits in the food and ag space. Most of our clients are Hudson Valley, Catskills, sometimes further afield in the state. And we help clients with the range of small business, small nonprofit work. A lot of it is helping people establish businesses, establish nonprofits, and get tax exemption, negotiate contracts, very often farmland leases, which we're going to talk about today, and then kind of a variety of other regulatory work. So we try to do what we can to represent clients that fit into our wheelhouse of what we do and that are appropriate for pro bono representation. We can't always represent everyone, but we're always happy to talk to people and try to refer out when necessary. So beyond this 1 hour conversation, if people have potential projects they'd like to reach out, whether it's something we could represent a client on or something that we could come up with ideas for referrals, we're always happy to talk to folks. So I'll leave it at that and look forward to the conversation.
All right, thanks, John. So this is our beautiful campus. We're located in White Plains, and we'll be talking about farmland leasing today. I'm going to try to get through this presentation in 20 minutes or so that we have the remaining half hour for conversation. There's obviously a lot of detail and a lot that can be said about this topic, and I'll try to keep it at a medium level so that we can introduce a lot of issues and then discuss them as a group. I owe a debt here to Melinda and Michelle from CCE Sullivan County. I gave a presentation similar to this last year, and I've adopted some of their slides at the start. And so I just want to give them credit. I've made some changes, but give them credit for laying out the first couple of slides of this presentation. So I guess before you all start reading those words, I just want to start with a general observation and set some of the context that leasing farmland is we're convening here to discuss how to do this in a fair and equitable and just way. I think we're all here, whether we're wearing a nonprofit hat or just as individuals or as business owners, we're all here motivated by what we perceive as sustainable agriculture and building fair relationships on the use of land. And the legal context that this occurs is in leasing, and leasing farmland is from a sort of dry perspective, it is a commercial contract. It is a commercial enterprise. It is a relationship between two parties, effectively for business purposes. And for that reason, the document, the lease, the written agreement, will reflect many commercial and practical considerations between the two parties. It's our job as lawyers and you all as either landowners or farmers to think through your needs in this relationship and articulate them to each other and to a lawyer if you're getting help from one in drafting a document, so that the relationship is clear and fair and the document captures it. I say all this because in commercial leasing, there's very little that the law, the statutes, or court decisions require to be in a lease. It really is a document that is intended to capture the breadth of your arrangement. And so everything that we're talking about in the first few slides here are issues that you should think about and negotiate and decide between each other to go into this document, but they're not by any means required by law. And there's some commercial standards, there's some expectations that we can talk about of things that should go in this lease and ways that relationships, the obligations, the duties can be balanced between the landowner and the farmer so that the relationship is fair. But you can think of it as a starting from a blank slate in terms of building a relationship, with some exceptions. So I want to first point out that our clinic has developed, been using, and also is happy to share a farmland lease template. This is the document. You'll see that it includes suggested provisions, optional language. It's very colorful and uses bold and italics to alert you to read that some of these are suggestions, some of these are just ideas, and there's blanks, and you're welcome to adapt it to your situation. So this is a starting point. It's not the ending point, and nor does it contemplate everything that you might need out of this arrangement. But just as a starting point, we do have this document, we make it available, and we update it regularly based on new things that we learn and new leases that we negotiate where we think, well, we've learned from this situation, we should actually be incorporating this into our template. And actually, just the other day, while we were drafting something for a client, Professor Brown was updating the template. So we are always going back to this document and refining it. Last time we really touched it was about a year ago, but I suspect we'll be making some additions this year as well. That can be included in the materials that are sent out. So with all that said, what are the provisions that you would normally find in a farmland lease, and how should you be thinking about them? These are the slides from CCE Sullivan. So first and foremost, might be on your mind, what should I charge as rent? There's a number of ways to consider that. You could think about your own costs for owning the land. You could think about what competitive rates are in the area. That's very hard to determine as a reliable data compared to, say, real estate values or sales comps. Rental rates are very hard to determine in an area other than by asking around. You can also think about, from the farmer's side, what is their expected return on a particular crop, if you're thinking about a crop share or something like that, or revenue share. And of course, renting raw land is very different than renting buildings or improved land. So you can also think about the value of the asset that you're renting, how well it suits a farm business, how well it's prepared to be operationalized, in the first season of a rental arrangement. The lease is a legal document. It is intended to be binding on the parties that sign it. And so one thing we pay very close attention to in our drafting is the description of the land. We might, as individuals, we might colloquially refer to property based on its street address that's used by the Postal Service, but if you ever looked at a deed, that doesn't have a street address on it. The way that real property is described is different depending on what source of information you're looking at. So a deed might use meets and bounds. You might tell your friend your street address because that's how they get there, but the government taxes it based on a parcel ID number. And then you can always, view things from maps, and Google Maps makes life very easy these days. So we use a combination of these tools in order to describe the property that's being rented. Of all the things to be confused about a few years down the line in a rental relationship, the one you want to be confused the least about is what land is being rented. So we use a combination of tools to be as specific as possible about what property is being rented and is available to the farmer. There will be rights for each party in this relationship. It's not just the landlord letting the farmer on the property and do whatever they want. Landlord often retains rights in this relationship to inspect the property, to enter in case of emergency or for repairs. I've seen landlords retain the right to, review business plans or review crop plans, things like that. So uh, the right to review and approve of proposed improvements or any kind of dramatic material changes to the property. Those are reasonable expectations from a landlord's perspective, because those choices that may be made by a farmer in a season or year over year will have a lasting impact on their property. So it is reasonable to request that from the landlord's perspective. Improvements can be a very tricky issue. Um, I would observe generally that in this time in history when agriculture is changing and land is not necessarily built for the types of agriculture that the people who are bringing onto it as tenants may want to be performing. So there'll be lots of changes to the infrastructure and improvements in order to accommodate different production styles. Uh, the classic example would be a dairy farm that is being converted into a small vegetable operation. The buildings are maybe no longer relevant, and there are new structures that have yet to be built that need to be there, and the where the water and electricity is run is different than where water and electricity is run or would need to be run for a vegetable operation. So there will need to be capital reinvestment in a lot of these properties, and how those decisions are made and financed are a very important part of a lease. Um, and we can talk about what a fair way to manage that redevelopment would be. It's obviously property specific, party specific, but there are some trends that we could discuss. Uh, a well-written lease will obviously allow for agricultural use. That's the purpose of this lease, but it should be specific or as close to capturing the desires of the parties as it can be in regards to getting organic certification or prohibiting certain practices or encouraging certain practices uh, that would impact the quality of the land and also the quality of the product. Uh, Back to payments, if you determine an amount that's in cash or determine an amount that's in, crop share or food share, it is important to think about when those payments will be made and how they'll be calculated, and try to be clear about those expectations. And just some tips from being in practice that as a landowner, your expenses come in January when you pay your town and county taxes, in the fall when you pay your school taxes. Could be depending on when you pay your insurance premium. Your expenses of owning the land come at certain times, and those times might not be the same time that the farmer has the cash in hand to pay the rent. So that can be a bit of a balancing act, but there should be a way to manage the basically cash transaction between the parties that makes sense for everybody. And also, when landlords and tenants agree to some kind of crop share, it's important to try to identify a value or a method of estimating that value so that the actual exchange is kind of quantified, even if it's not determined in time or is quantifiable, even if it's not determined at a dollar figure in the initial drafting of the lease. And I guess back to the point about improvements, uh, there is a lot of land remediation that can be required depending on the property. And so it's important to consider who will be responsible for that, what is the quality of that remediation, and how does that benefit the farmer who needs it in order to run a productive business, or benefit the landowner in the long term by rehabilitating the property. That can be a value that's exchanged in the lease, or something that is paid by the landowner and then credited against rent. So something to consider about depending on the quality of the property. A couple last points here. The length of the lease can be very important for farmer security. The flip side of that is landowner security. If you have a 5-year lease for a set amount of rent, you are guaranteed that income. That's the tenant's obligation to pay that rent for that term, absent any defaults or terminations. So there is a mutual benefit by engaging in a long-term relationship. And uh, it is still important to determine what the right length is for the relationship, and that can change over time. So it might be appropriate to offer a 1-year lease if someone just needs to move some head of cattle on a property and graze it, because those cattle will be gone in a few months, and if they return next year, that could be another agreement. That might be appropriate. But for a vegetable operation that, highly diversified, intensive vegetable operation, it would be a big ask for a farmer to commit to a property and getting themselves set up and not offer them more than 1 year because of the amount of effort it takes to move and establish and put fencing up and just design basically the vegetable patch. So we usually advocate for 3 to 5 years. We often really start with 5 years as the minimum lease term. And of course, if you get into perennial agriculture, or really if it's a mature relationship where the farmer is kind of building their homestead, so to speak, on a property, then it's appropriate to be looking at 10 years and greater in these lease terms. Um, of course, this is a relationship building process. So if you're not comfortable with renting your property for 10 years right off the bat, you could work towards that using renegotiations along the way or renewals along the way. Uh, some some other points here. Insurance is usually paid by both parties, but they're different policies covering different events. So landowner will pay for insurance that covers damage to the property. The tenant will pay for insurance that covers crop loss or replacement value of their equipment. Sometimes insurance policies can overlap, and it's okay to be sort of double insured, but uh, and listing each other as additionally insured parties. Taxes are usually paid by the landowner, but the farmer's presence on the property may reduce the property taxes through the agricultural assessment. So that can be a bargaining position. And utilities, usually the tenant pays the utilities that are due to them for their business, but that can often be difficult. Like what I said earlier, if a house and a barn use the same meter and same well, that can be difficult math to kind of untangle who's responsible for what increased electricity usage. So it's important to walk the property and understand how the production will integrate or sort of work side by side with whatever other uses going on in the property. And contracts are legally binding documents. We write them so that the parties can understand them in the future, but we also write them so that lawyers and judges can understand them in the future. Every contract can be put to court, but we also include a provision that recommends and encourages the parties to keep an open line of communication and to use mediators if necessary to resolve a dispute before going to court. And I'm sure some of you are familiar with the ag mediation program in New York State that provides free mediation services for landlord-tenant relationships in agriculture. So we highly recommend them. And we might think of a dispute or a conflict as something that's sort of, blown out of proportion or really challenging, but they will also send mediators just simply to help you build a relationship as you begin a leasing landlord-tenant relationship, or middle of the road if you're renegotiating or your relationship is taking another form. So mediation comes in many shapes and sizes, and they can be helpful in all different stages of a relationship. Okay, so I'd like to mention a couple of scenarios that sort of come up often in our clinic that are challenging for us to draft in a document. Suppose they can be challenging relationships as well, but I just want to point these out because they make for complex negotiations and complex drafting. Just as to say that they shouldn't be
It's about farmland.
engaged in, or that I don't recommend them. There we go. But just they become challenging. So the first is if the landowner is not living on the property, they're absent. Maybe they're there on the weekends, or maybe there is no home, they're not there at all. But they have a high expectation for property aesthetics. Farming can be a very messy business, both in its literal mess, but also the amount of tools and materials that are required and where you store them all. So it's important to talk about what the aesthetic goal is, and then if there is an aesthetic standard, to be careful about how you draft that, because it's very, other than my background image here, there are very few farms that are neat and tidy. So it's important to sort of set expectations around what a farm looks like, and it's going to change throughout the year, definitely. So another tricky situation is where the landlord is present and they have their own farm business or their own homesteading or their own, agriculture, their own kitchen garden or livestock, and they are expecting the farmer tenant to assist them with that in lieu of paying cash rent. There's nothing wrong with this relationship. It's actually feels quite natural and can be mutually beneficial. It's just pretty challenging to draft and articulate what the responsibilities are in both directions, and for that to stay a fair and arm's length transaction and avoid sort of merging the two businesses. Another situation is if the landlord has the high aspiration of creating farm collective. I put that in quotes because that can mean a lot of things to different people. But basically bringing on multiple tenancies onto the property, because now you have multiple farmer tenants who have one contractual relationship with the landlord, who is then managing these different business operations and their rights and responsibilities. But it's all kind of directed towards the top, and it can be very hard to make uh, the bring the multiple tenants together in some kind of committee or advisory process. It's hard to draft. It's hard to really picture what the right thing to do in that situation is, despite the best intentions of making what usually is a larger land mass available to multiple smaller operations. And then the last one is quite common, that the tenant is a farmer, a commercial tenant on a property, but they're also renting a residence. So do we capture that in one document? Do we capture that in two documents? What are the rights and responsibilities as a residential tenant versus a farmer tenant? In a daily life, it's all kind of one thing, but if you have two different documents that conflict with each other, it can be very challenging if there's ever a problem, meeting the standards or paying rent, that you have these two conflicting relationships. So again, these are challenging situations. We're not forbidding you from engaging in them, but they can be difficult to navigate, to negotiate, to arrange, and difficult for us to draft. I'm going to give two more slides here just on some legal background, and then I'll wrap it up. I started this presentation by saying most everything that's in the lease, in the commercial lease, is for you to decide, for you to negotiate and arrange, depending on your property and depending on the relationship you want to build. Really is customizable. I want to mention a couple of things here that are in the statutes that might help guide you or just think about it in additional ways. So we do recommend longer term leases, medium term leases, for the sake of farm operational security. It's very hard to move a farm. There is this law called the statute of frauds, which basically stands for the fact that a lease that is less than 1 year, or any lease that is more than 1 year, must be in writing to be enforceable. So handshakes that are intended to be for multiple years are not enforceable against either party. So that's why we draft leases, because they're required under the law in order to be enforced. The flip side of that is that if you have a handshake for 1 year, it is technically enforceable, but happens in that situation where there's a conflict, you're going to town court and both giving testimony. It's still not a great situation. Even if you're engaging in a 1 year lease, it should put it in writing. And if it's anything longer than it really is required to be in writing. I mentioned some tenant protections for residential situations. I think we're probably all familiar with them. Generally speaking, that especially as this is a new priority for the New York State Legislature. But just some other commercial landlord-tenant laws that might be relevant. Self-help, this term here, this is a situation where landlord is locking the gate, so to speak, on the tenant who has failed to meet their obligations or to pay rent. That's only allowed if you specifically reserve that right in the lease, and that's based on a court decision. Otherwise, evictions in the formal process require a sheriff, require law enforcement to carry out the force of the terminating the relationship. There's something called a Yellowstone injunction. I haven't read the case that's called Yellowstone, but it's the tenant, the commercial tenant, gets the court to allow to maintain the status quo while the proceedings are going through the court system. So this is a way for the commercial tenant to sort of pause the eviction, continue their occupation and use of the premises, so they aren't unjustly denied while they're going through this process. And similarly, they can recover possession if they've been locked out. And lastly, there is this provision in real property statute that if the landlord unlawfully evicts a tenant, then the landlord could be subject to triple damages. So I've seen this come up where the landlord was locked the tenant out of the like wash pack building, but that was also their cold storage building. So they had multiple weeks of saleable product in there, and that you added it all up and then tripled it, like really what the commercial damage that could have been caused in this situation was in the tens of thousands of dollars. And so communicating that made it very clear that they need to resolve their dispute in another way and work towards mediating the underlying issues, take the lock off the wash pack, let them continue their business operations and get to the end of the season. So that is something that can be enforced through statute. And then just some last minute here, some practical tips on leases. When leases are long in nature, they can be recorded. So anything over 3 years can be recorded in the county clerk's office, like a deed would or a mortgage would be recorded. You don't have to record the whole document, so all of your, nuanced relationship that's negotiated into the document doesn't need to be in the public record. But all you need to do is put the names of the parties, the lease term, and if there's any renewal option. That basically notifies the public that there is a landlord-tenant relationship, there is a valid leasehold on a particular property, and that gives notice to any particular, or any new proposed purchaser or business or venture that there's a valid leasehold that binds the property. I don't think people record leases that are 3 years, but we've worked on some leases that are 30 years, meant to sort of imitate a generational term or a career term, like a 30-year lease or a 40-year lease. Those are worth recording. That's a durable right that's announced to the public. So those are worth recording. And then at the farther end, if you get into the type of leasing where you're really trying to mimic ownership, like something like a 99-year lease, you start to get into transfer tax territory. So any lease that's over 49 years in length is considered a transfer under New York state law. So a tax is owed on that, like it would be if you sold the property. So just be careful of that if you're not intending to create that kind of relationship, or if you're not intending to be taxed, just be mindful of that 49-year length. I have some slides here about the ag assessment program, forestry program, and I have some slides here about home rule, ag use, 305A review. It's not really the topic of the presentation today, but I include them because they're relevant to your understanding of your property rights and state tax law, and they can come up in lease negotiations based on the value of the farmer being on the property and the uses that they intend to bring onto the property and how that might change the property owner's liability or position with the town government. So these will be here in the slides. We'll hand them out afterwards, but I won't go through my whole presentation on this right now. All right, thank you for listening. That was as fast as I could address as many things as I could address.
Thank you, Jack. That was really a great resource for everyone. I personally resonate with a lot of points that you've made, and thank you so much for your presentation. I haven't seen. Well, thank you everyone for posting all your information, and I really do appreciate that. I haven't seen anyone's question yet. I just wanted to open up to the floor. If you guys have any questions, please, by all means, raise your hands, turn on your mic.
Jack.
Hi, Bert.
Hi. You talked about 3 years being when you should record a lease. Have I heard correctly?
Yeah,
Give some clarification on that. If
sure. 3 years is the minimum length of lease that can be recorded with the county government. In our experience, nobody's interested in recording 3-year leases, but we've drafted 30-year leases and we've drafted 99-year leases, and those are, durable, long leaseholds that deserve to be recorded, put the public on notice.
I saw that there was a template for a lease, and I wouldn't post that on the Ulster County website because it's kind of like it's too legal to do that. But I was wondering if I could direct interested landowners and farmers to PACE, and you would disseminate that.
Yes, we can share that document with you to share, or if you want someone else to share it so it's not coming from
Well,
Ulster County government, that will be fine
well,
too.
people will ask me to explain it in
Yeah.
detail, and I may get some things wrong, and that's my concern. So, but
Yeah.
I guess I can have it on hand and give it to people who are interested, and just say, if you want to follow up, go to PACE, go to their website. So,
That would be fine. Yeah, I don't think we actually have it posted on our website, but we do share it uh, with the attendees who are registered to events like this and with other service providers. So it is widely available, but I don't think it's actually hyperlinked on our website either.
okay. Are you going to share that with the people who attended this webinar?
Yes.
Okay, thanks.
Bert. Jag, we have a question from the chat. It's from Sam. Have you encountered capital improvements that come from project-specific grants? What happens when lease ends and tenant leaves? Does the tenant get paid?
It's a great question. There's a couple of questions in there. Yes, there are capital grants available from the state and federal government that pay for farm improvements and will pay for farm improvements even if they're on leased land. I think the question is sort of twofold. What happens to the improvement if the tenancy ends? And then the second half is, is the tenant in violation of a grant agreement, or does the landlord have to take over the obligation of that grant agreement or something like that? It can be a tricky situation. Um, I guess our general, well, let me answer generally about improvements. So, like I said, it's a freely negotiable document. There's no perfect way to do it. Obviously, the tenant needs an improvement for their operation, but it could be beneficial to the landlord in the long term. So balancing the time and the money is a negotiable moment in a lease. What we have in our template suggests that if the tenant takes on the full expense at the outset, that any remaining value at the end of the tenancy would be paid back to the tenant by the landowner, who retains the value of that improvement if it's permanent. If it's temporary, they can pick it up and take it. That's the general rule that we set out in the template. We've seen other situations where the landowner desires the improvement for their own benefit and they finance it in full, and then they raise the rent to recoup some of the investment that they made, and that benefits the tenant. There's nothing wrong with doing it like that either. When you factor in the capital grants, I guess I'd turn the question back around to the group if anyone has experience with that situation directly. I know the grants that are out there right now, the FVI grants, will fund capital improvements on rented land. I don't know what happens in a grant agreement if the tenancy ends basically during the sort of term of the agreement. I'm not sure what the grant agreements would say about that.
Thank you for the response. I have the next question from Omar. How's the risk of physical injury allocated in the farm lease? Whose insurance? Is it landlords, tenants, or both to cover?
There's, like I said, there's a few different insurance policies that could be at play here. The farm business should have a general liability policy, which could cover injuries. It might also have a workers' compensation policy, which would cover injuries to workers. And the landlord should have some kind of property insurance. If there's a home on the property, it's probably an extension of that residential insurance. If it's vacant property, there's no home, there's other sort of vacant property insurance for basically for casualty, for fire or flood or damage like that. Usually insurance is insuring a building on a property. So from the landlord's perspective, I'm not sure that their property insurance would necessarily cover personal injury unless it was a residential policy that covered, guests in the home. It could be extended to the farmer tenant and their employees and invitees on the property. I've not seen a policy like that, but generally the general liability policy of the farmer tenant should cover personal injury to third parties. And it's reasonable to expect that the tenant would extend that coverage to cover the landlord. There's also indemnification provisions, which are ways of shifting liability in personal injury lawsuits between the parties.
Great. Thank you, Jack. Could you clarify the process of gaining tax break through agriculture, whether it's a tenant farming or landowner? I've heard it exists, but I'm not sure on the process. And I think it's referring to agricultural assessment.
Sure. Yeah, agricultural assessment is a program through New York State which lowers the taxable value of real property from its full market value, any and all uses, to its agricultural value based on the productivity of the soil. And that can be achieved through a rental. It doesn't have to be the owner that is farming the property. It's administered at the town level, so you'll need to talk to your town assessor and supply the forms to them. But it is a state program, so the forms are available on the state website, and the eligibility is set by the state. The general rules are if you're farming a small acreage, 7 acres or less, then you have to earn $50,000, 50, on the farm production. And if you're farming a larger property, greater than 7 acres, then you need only show $10,000 in farm sales from the production. And the town assessors will ask to see, if it's their first time enrolling, they'll ask to see the Schedule F tax form or some other financial statement from the farm operation to verify that income. The other little trick of the program is that if a farmer is farming on multiple properties and their business generally qualifies on one property or another, they can qualify all the properties if they have a 5-year lease. And so in that situation, it is very beneficial to the landowner to have a 5-year lease so that they can basically automatically qualify the property based on the farmer's income generally, rather than their income just from that property. So earlier I gave the example of a 1-year lease for grazing cattle. That's the perfect situation for a 5-year lease to guarantee the agricultural assessment, because presumably that cattle farmer has multiple properties that they graze or cut hay on through year to year, depending on what cattle they have and where they want to move. That's a good situation for using a longer term lease, making a longer term commitment to basically ensure the agricultural assessment is applied to the property and lowers the property taxes.
Thank you, Jack. For that topic, our particular town, usually the deadline is March 1st, and so you have about half a day to.
Yeah.
Great. So next question, going back to the question related to capital projects, capital improvements. Should any capital improvement over time and as they occur be included in the lease? So is the lease updated and current?
Yeah, John, I saw you unmute when we were talking about capital improvements before, so maybe you can take that one and add whatever you wanted to add.
Yeah, sure. Yeah, I think Jack did a good job of addressing generally, one of the ways we advocate for addressing capital improvements. I think it's a challenging thing to address. at the outset of a lease in a way that covers every situation. So what we suggest, and again, not the only way to do it, what we suggest in our template is create a mechanism for how there can be an arrangement agreed to between the tenant and landlord for a particular improvement that's proposed. But that's not saying that you necessarily pre-agree at the beginning of the lease that this is how we will treat all improvements, and that anytime the tenant invests in an improvement, the landlord's on the hook to reimburse. So instead, basically, it has to be a conversation each time something comes up. Each time the tenant wants to invest in an improvement, it's a conversation to understand the cost, the useful life of the improvement, what it involves, and is the landowner interested in having that remain on the property and potentially being responsible for reimbursing the tenant for some portion of that. So it's not the only way to approach it, but that's what we suggest as a useful way to approach it, which is that you do have basically a schedule, a running log of improvements at the back of the lease. And each time there's a proposal, that's an opportunity to put that down in writing, record it if the landlord actually does approve of it being built, and accepting that responsibility to reimburse the tenant for whatever remaining value there is if and when the tenant leaves at the end of the lease. So a long way of saying, yes, it doesn't have to be recorded, but we think it actually is a good idea to update the lease with that and have specific information updated in the lease.
Great, thank you for the response. The next question, any recommendations about including clause on prohibited, restricted, discouraged practices while also providing the farm tenant enough autonomy to run their operation as needed?
Yes to both. It's a balancing act. I think this is where transparent and open communication will be really beneficial to both parties. Sometimes certifications are more important to the landowner. Sometimes they're more important to the farmer. It's really important in your kind of matchmaking and relationship building to figure out as best you can what the underlying value is for property stewardship, and then drafting it from there. I think would include clauses on both. It would say specific things that are required or prohibited, and then also create some general rules about whether the farmer has decision-making authority over, if they're totally exclusive and free to make business decisions, which I think they ought to be, but what's the extent of that? There's emergencies in farming, crop emergencies that might need to be they might have to take some prohibited action in order to address. So it's important to know what the sort of hard lines are and the deeply held values are in property stewardship between both parties.
And this might go without saying. I would just add that being specific helps. Being vague can lead to issues, to unexpected results. If there's a conversation up front, exactly what the expectations are, specific practices that cannot be used, then it's either that's acceptable for the farmer to move forward on that basis, or it's not. But we've seen situations with vague language about standards or aesthetic issues, and aesthetic issues, for example, can raise all sorts of interpretive questions about what is appropriately unsightly for a farm or not. So again, specifics discussed up front in concrete language about what is permitted or not, that can be very helpful to address that up front. But vague language that could lead to a lot of interpretation about expectations, that can create more challenges.
Great suggestion. Thank you both. The next question, have you seen a subdivision done for the home to be separated from the farmable land?
Well, generally speaking, subdivision is a legal process for literally dividing tax parcels, creating two real estate parcels from one. So a lease wouldn't create that. That requires some applications through the town government to recognize two parcels that used to be one parcel, or many from one parcel. So just to be clear that a lease cannot legally subdivide real estate, but in effect, if you're only leasing some of a larger property, it does create a different set of rights and responsibilities for a smaller piece of that property. And in the case where land is being rented to a farm business, and the landowner resides in a house, you should be clear that the farmer is not renting the house from you as well. So that's back to the point about being very specific about describing the area that's being leased. It would be very natural and obvious to exclude the landowner's residence from their commercial lease with a farmer.
Great, thank you. I assume that it's specific to town, case by case, and also involves engineer and application process for planning, review, and etc. So
Yeah, it's not something I've worked on personally, but I do understand it can be quite involved
all right,
to subdivide land.
sure. The next question, can you talk about retroactive taxes for ending ag exemption?
Oh, yes, there is. It's important to say there is a penalty for removing a property from the ag assessment program, but it's only based on conversions of the property. So, letting a farm, ceasing a farm operation and letting the fields go fallow and grow up in brush and ultimately trees is not a punishable act, to my knowledge. But converting a property into subdividing into many small residential units and building housing development is a conversion that would subject the property to the penalty for withdrawing from the ag assessment program. I believe that someone could speak more to this if they know more, but I also believe that solar development on farmland is considered a conversion. And so in the negotiation over a solar lease, the acreage that's being removed from ag production and built into a solar facility, there's a penalty assessed, and that the solar company agrees to pay that penalty because they're the one that benefit from the conversion. Not to bring up solar.
And if I understand it correctly, I believe it's 5 times the final ag assessment value that you have to pay the penalty for.
Oh, yeah, you're right. It's like it's meant to recapture the multiple years of savings that the property had received.
And I would just add that there's also a tail. This applies if there's a conversion, not just in the year that you received an ag assessment, but for a tail of 5 to 8 years afterwards. I believe it's 5 years if it's in an agriculture district, 8 years if it's not.
Right.
So that's something to look out for, right? That's not just maybe not intuitive, but this lasts beyond when people are actually getting the assessment.
Yeah.
Sure. There's a question. Please go ahead.
Yeah, it's about that ag assessment, and so the ag assessment is a New York State thing. Is it necessary to be in an agricultural district in order to get the tax exemptions on the town level, or?
No, it's not.
It's not. And is it so because I as far as I found out is that in order to become part of the ag district, a lot of it has to do with the soil maps and everything like that. So if you have, like, my land is poor soils for agriculture, does that affect the tax breaks on the town level, or is it based on what you're actually producing?
I know some counties south of Ulster County put like soils requirements, but the state statute doesn't do that. It doesn't even have a size requirement. What was the second about taxes?
Yeah, so if you get the agricultural tax breaks on the town level, that's determined by how much you're producing on the land in a dollar value, or is that based on the soil maps? Or I'm not sure how that tax break goes.
I'm not a tax assessor.
Yeah.
But for ag districts aside, the ag tax exemption, soil maps come into play because there are these mineral groups, and the better the soil is, the more of a tax break you'll get. But as for, I mean, Jack had mentioned about these gross sales requirements. Like if you're, I guess 7 acres in production or more, you only need to gross 10,000. So you could be losing money hand over fist, but if you're grossing 10,000 or more, you qualify for the tax break. And there's more to it. You should talk to your tax assessor. I'm not one of those.
Okay. Yeah, it's a more detailed per town.
Well,
Yeah,
no,
and
I mean the tax law is a tax law across New York State, but I spoke with a journalist, they're talking about Putnam County
That's
with
where I
ag
am.
districts,
Yeah.
and they add like these soils requirements, and
Yeah.
I'm not familiar with it because it's really different where I am. So
Okay.
we've had large fields that have bad soils, but they're large fields, and
Well,
they're not gonna. So
that's where I am. I have 100 acres where they're poor soils. That's what the county told me, that I don't qualify for the ag district because of the poor soils. But I mean, I can have livestock on there. If I can run pigs on there, I can
the
produce plenty of
the
sales.
there's no restriction in the state law that says that if you have to have a particular type of soil or soils to get into an ag district. But I know, and I don't understand how they do it because I haven't really studied it. It's like Putnam County puts these additional restrictions, and Westchester has some sort of restrictions. I haven't really studied them because it's just not what I need to deal with up here where I
Right.
am.
I can add
Basic,
also, sorry, Bert,
sorry.
in the interest of time, I also went through the ag assessment just recently, and in particular to our town in Orange County, they do require soils map. So I had to go to the water and soil district to get the soil map, and based on the soil classification, I think it's going to be reflected on the ag assessment value, and that's basically proportional to the tax savings that you're going to get. So better soil, more savings, worse soil, less savings. So that was particular to my town, but it was my conversation with the assessor and also the soil and water district. All right.
They're allowing you to farm, but they're not putting you in an ag district because if they do that, it becomes harder to shut you down if there's an issue.
Right. So you don't get those civil protections that you would in an ag district, but as long as you fall within the town codes and whatnot, that's what I've
Yeah,
been told. But yeah, it's just a little. It gets confusing going back with the soil tests, and you have that. I guess that gross sales thing is like a baseline to get any kind of an exemption, and then it's a sliding scale from that point on based on your what they call production capabilities.
so it sounds to me that you can get an ag exemption, you can farm,
Mhm.
but they won't grant you this privilege of being in an ag district where the people who have to jump on the Metro North in the morning are being kept up at night because you're doing work. They want to be able to come in and shut down part of your operation if they have to, because
Okay.
those disputes with neighbors in towns get incredibly heinous.
Yeah.
I had a neighbor just like fly after me on Facebook on something. And so I think um, the further you are from, downstate, we'll say,
Yeah.
I think, the the agricultural and farmland protection boards and the legislatures will allow ag districts properties to be in the ag district program more often.
Yeah.
and I'll just add that I can't see your name because it just says iPhone. But if you'd like to contact us, we'd be happy to talk with you directly and look
Oh
at
yeah.
Putnam County in your town and try to help you resolve. If you have an issue, resolve it, or maybe just be prepared for the next time you want to raise it.
Yeah. Yeah. I'll reach out to you for sure.
All right. Thank you so much for both. And thank you for everyone to participate in this webinar. And I will follow up with all the materials and recording with you. So thank you very much. I just needed to be a little punctual, so I had to, and I'm sorry for halting it so abruptly, but thank you so much, everyone.
Thank you.
Thank you.
Thank you very much.
Yep, nice to see you all.
Thanks, everyone. Thanks,
Thank you.
Eugene.
You.